Okay, it is 7 o'clock. I think it's probably about time for us to get started. So, good evening, everyone. I am Darren Houghton, the Associate Director of Community Outreach at AARP Utah, and I want to welcome you to our AARP Utah University Series. Tonight, we are going to take an in-depth look at, my notes just jumped up the page. Tonight, we're going to take an in-depth look at wills and estate planning. And so we're glad that you can join us. So let me put our presentation up screen. Oops, the wrong one. Sorry about that, everybody. Can you see my screen now, Alan?
Yeah,
Okay,
it's just the script right now.
it's just the script that you're seeing? Okay,
Yeah.
that's not the one I want to show you. So let me get out of that one. And I will share the correct one here. Sorry. Okay, there we go. You can see it now, correct?
Yeah.
Okay.
Looks great.
So the first slide that you're looking at is before we get started, we want to give everybody the opportunity to enter in for our first quarter drawing for a chance to win $1,000, $100. They're all like, yes, I'm going to hold that to you now because I heard $1,000, but it's really $100. All you have to do is scan that QR code on your screen for a chance to win. To enter, you must live in Utah and be 50 plus years old. Only one registration per person. And to scan that QR code, all you have to do is open your phone and take a picture of it. A link should show up in your viewfinder. You click on that link and you should open to a web page where you'll be able to sign up for the chance to win this $100 Visa gift card. We will leave it up here for a few minutes for you to get a chance to take out your phone and to enter into this drawing. But while we're doing this, let's make sure you're familiar with Zoom. First, if you're having any trouble seeing, hearing, or simply it's just going wrong, just refresh your browser. That will give you the opportunity for it to reset. If it has old data in there and it's using possibly an old link, when you clear out your browser, it gives it a chance to actually use the correct one. If you are experiencing technical issues after refreshing, please submit your issue in the chat box and one of our AARP Utah team members will respond. Please make sure that you are mute on your audio and that your video player is off. And to answer the poll questions, a poll box will pop up. You will choose your answer and we'll be able to see the results in real time. So let's try this before we get started. We're going to try our first poll question. And so I'm going to come over here to the computer and let's do our first poll. So the first poll is, when you wanted to find out about today's webinar, how did you find out about today's webinar? So choose either a postcard, email, Facebook post, or other. So right now we've got about 50 people participating. We have 372 people that are on the webinar right now. So here's your chance. We'll give you another, and we'll see what the results are. Okay, so let's end the poll. Back over here and end it. So 65% found out about today's webinar via email, followed by other, and then a postcard. Our Facebook post was the shortest. So let's share those results so everybody can see them. And let's go to the next question. Well, it looks like it did all of them at the same time. Ooh. So the second question was, do you have an up-to-date will? So Alan, what do you think, based upon people's just kind of, before we get to the part where you actually ask the second question, what would you think would be, if the participants have an up-to-date will, what would you think their answers would be right now?
I would guess, based on having done this an awful lot, that about 20 to 25% say that they're fully up to date. Maybe 60% said no, and a few say they want to live dangerously.
Oh, okay. So let me go see what they said right here. I know we're kind of jumping ahead a little bit, but let me just show this since it's already done. If I can get over to my screen. There we go. So can you see this result on your screen? It's question number 2.
Yeah, you have to kind of drag down that little gray bar.
Yeah.
Yeah,
Can
it doesn't necessarily surprise me, the 24% that it's up to date, but I am surprised that there's so many people who want to live on the edge. Hopefully, we'll fix that tonight.
So I'm going to close this out, and we'll continue on with the presentation here. But for the other question, because they answered all 3 of them at the same time, I'm getting better at this, and we'll see how this goes. So again, here's again the answer, the quarterly drawing, but we asked this question. So let me go back over to here. So in today's session, wills and estate planning is extremely important at any age. Most people have property and they want to pass it on to their family, friends, and loved ones. And the purpose of today's webinar is to help you understand how to pass your property on in the manner that you choose. So let's kick off with a quick video. So I'm going to come over here to this next slide and we'll start the video.
Darren, I don't know if there's a button you can push to make the sound happen, but it's looking like the sound isn't working.
Oh, okay. Let me go back to how to fix that. So when we do the sharing again, I have to allow sound, which is on the bottom. Sorry about that. So let me go back to here and share this again. Thank you for all the people that are chiming in and helping me. Let me go back and then we'll start.
Family business? Do you know which life events would trigger an estate plan redo? Well, here are 5 things to consider. Have you gotten married, remarried, or divorced in the last 12 months? Have you added a new addition to the family? Maybe you've outlived the person you named as the executor in your original estate plan. Have you increased or downsized your family business? Maybe you moved to a new state. If so, you'll need to see if your current estate plan meets your new state's requirements. Any major life change should get you thinking about how best to protect your assets and your family legacy. For more financial information, go to aarp.org/money.
Okay. And so with that, we're very excited to introduce today's presenter. It's someone that you should be very familiar with, or if not, you should get to know. This is AARP State Director Alan Ormsby. Alan, welcome. Thank you for your patience with all the technical issues, but you're a master at this, so this should be quite easy for you. Anything before you want to begin? Before I go off screen and turn it all over to you, anything that you'd like to add to the group or anything?
No, I would just say if anybody has an open microphone, mute it. But otherwise, hopefully the sound quality is good, and ask me any questions in the chat. Yes, this is being recorded. Yes, you will have a copy of it. So don't stress about trying to take a million notes. At the very top of the chat, there's a link for an outline as well. And Darren, maybe if you'll put that link in half a dozen times throughout so people don't have to go scrolling to the very top.
Yep, I will do that once I go off, all right? Okay, I'll turn the time over to you now then, Alan.
Okay, thank you. Well, as Darren mentioned, almost everybody has someone in their life that they want to be able to pass their assets on to. I'm going to spend about 30 minutes talking about just exactly how you can do that. And this presentation is specific to Utah. I think anybody who's listening will get something out of this, but keep in mind, every state has their own way of doing things. All of this is for educational purposes, not legal representation. And double check in your state. I'm going to say a lot of things that are fairly Utah specific, and I'll try and point those out. But if you have questions, be sure that you're talking with someone in your state to make sure that it works for you as well. All right, so let's talk about the excuses. Do you need a will, and why haven't you done it yet? Well, here are some excuses. There are name tags on the bottom of all the knickknacks and furniture. I don't have much. The kids can just come in and take whatever they want. Last year, I put all my money into a joint account with my oldest daughter. She knows she's supposed to split it with her brothers when I die. And the last one, everybody knows who's supposed to get what. Well, what's the problem with all of these? The fact is, none of them will be legally sufficient. So, the question for most people then is, do you need a will? Well, truly, you might not need a will if you own no property, if you have no children, no family, or no one else, like a charity, that you may want to benefit. And I'll get into that just a little bit more in detail. If you truly don't care about how your property is distributed after you pass, then you might not need a will. But that's not most of us. Darren, if you can advance the slide. Go one more. You definitely do need a will if you have minor children or other dependents. If you care about how your property is distributed after you die, if you want to include anyone other than family. And this is really a critical point. I'll kind of emphasize this in a second. But if you want to benefit, say, a charity or a friend, if you don't have a will, the state is not going to look for your favorite charity or your friend. And if you don't want the state to divide up your property, you definitely need a will. So that's almost all of us, right? So let's talk then about how you go about creating a valid will and what happens if you die without a will. Next slide, Darren. So what happens if you don't have a will? It's called dying intestate. And it's just a fancy way that lawyers say you died without a will. The state appoints someone to wrap up your affairs. That person is called an administrator. In some places, it's called an executor. That person may or may not be the person you would have chosen or your family thinks is appropriate, to execute the will or execute the estate if there is no will. And sadly, family bickering often begins at this point. The state's going to use a formula to decide how your estate is divided up. And the way that formula works is pretty simple. The first thing they do is they look to your spouse. And if you are married, and it does not matter if you've been married for 10 minutes or for 40 years, the person that you are legally married to at the time will take the lion's share of your estate. And often this happens in second marriages or third marriages where the families don't necessarily want all of the assets to pass to the spouse. But in the absence of a will, that is what is going to happen. The lion's share will go to the spouse. If you're not married, then the state will look to your children. If you don't have children that are alive, the state will look to your parents. If your parents aren't alive, then the state will look to your brothers and sisters. And after that, it gets really complicated really fast. And so if you have family that is a little bit further apart, it can be really difficult to make sure that those proper heirs are being provided for. And as I mentioned, the state is not going to look for your favorite charity or for a friend of yours, a person who's special to you but isn't related to you. So if you want to ensure that those people are provided for, be sure that you craft a will and be sure that you keep it up to date. If you don't have any family at all, and believe me, the state does not want this to happen, then the property escheats or goes back to the state. And I think none of us really want the state to get our assets. All right, next slide. All right, so I'm going to go through a process tonight and tell you how to create a valid will. There's really very simple steps to this, and it's not as hard as you might think. So I'm going to tell you how to do it yourself. I'm going to describe something that's fairly unique to Utah called a holographic will. And then I'm going to tell you about what you might expect if you go and see an attorney. All right, so the first step is you need to determine whether or not you have legal capacity. This is pretty straightforward. You basically have to pass a three-part test. You have to be able to generally describe your estate. I have a house, I have a piece of property, I own 2 cars, I have a collection of coins, that kind of thing. Doesn't have to be perfect. You don't have to be able to describe it to the amount of money that's in your 401k. You just have to basically be able to describe what your assets are. The second step is you have to be able to say, this is who I would like to be my beneficiaries. And you have to describe that. Say, I've got 3 children. I want to split this with them. 2 of the children are doing very well. 1 of them is really struggling. The 2 that are doing well, I'd like for them to have 25% of my estate. And the 1 that's struggling, I'd like to have 50% of my estate. Then the last step is you have to be able to describe the consequences of the decisions that you've made. Yes, I understand that the 2 older children might be disappointed that they're only getting 25% each, but that last person needs extra money. So as long as you can do those 3 things, then you have legal capacity. So once you have established that you have legal capacity, you're going to have 2 witnesses. In Utah, it's 2 witnesses. It does not have to be notarized. You're going to have those witnesses who will describe and say, yes, at the time that I witnessed the signature, that person did have legal capacity. So the form of the will doesn't have to be fancy or anything else. You can just write at the top, will, last will. If you want to sound like a lawyer, you can write last will and testament. But the first paragraph is going to say, I have legal capacity. So you can say something along the lines of, I, Alan Ormsby, having legal capacity, create my last will. There you go. So then your next step is to make sure that the will is dated. And why do we want to make sure that the will is dated? Well, you may do this more than once in your lifetime. And the court is always going to look at your most recent will in time. If you can make that as easy as possible for the court, that's a great step. So be sure that you put on it a date. And then you're going to want to actually say that you are getting rid of any of the additional wills that might have been created in the past. This is a little belt and suspenders, to be honest, because like I said, the court's always just going to look at the most recent will in time. But if you can, again, make that job easier for the court by saying, if I created a will in, say, January 1st of 2000, and I created another will in January 1st of 2010, and here it is March of 2026, you're going to want to say, I am getting rid of all of the wills, and you name them by date. That way, just in case somebody comes and wants to go to war, you've got good resources to say, no, this is the will that I want, and this is the one that it is the most valid. All right, so that's paragraph 1. I have testamentary capacity, and I'm creating it on this date. Second paragraph, you're going to name an executor and at least one alternative. An executor can be anyone over the age of 18 that they themselves have testamentary capacity. So if for any reason somebody's going to go to war over you having testamentary capacity, or maybe your executor having testamentary capacity, go see an attorney. It will be worth it. But as long as those things are relatively straightforward and you don't think anybody's going to have a fight over this, go ahead and proceed. Now, why do you want to create at least one alternative? Well, what if your executor passes away before you do? What if that person becomes incapacitated? What if that person says, I don't want to have to do this? You definitely want to have at least one alternative. Now, question I get asked all the time, should I have more than one executor? The answer is no. You definitely want to have only one executor, because if you name multiple executors, those people have to agree 100% on every step. And during emotional times, it's really difficult to get people to agree 100% on everything. So you might have 2 children and you love them both equally. Choose one of them to be the executor, and then choose one of them to be the alternative. I'm going to pause for just a second there. The next thing you're going to want to do is name a guardian for your minor children or dependents. If there's anyone who is under the age of 18 in your life, that person is going to need a guardian until they reach the age of 18. Also, if you have a child with a disability, that person may need to have a guardian named for them, even if they're over the age of 18. Can the executor and the guardian be 2 different people? Yes. Can they be the same person? Yes. So if you have a person in your life that's really good with money, go ahead and name them the executor. If you have a person who's really good with children, name them the guardian. And again, you're going to want to have at least one alternative, and probably more if depending on the ages of your children and things like that. All right. So the next step, the next paragraph is going to be the distribution of your personal property. Those are things like your cars, your collections, cash that you might have on hand. Those are the kinds of things you're going to distribute. And in the guide, I give you some model language. I say you're going to take any personal property that you have and you're going to describe it and say, if owned by me at the time of my death. So the example is, to Uncle Jim, I give my riding lawnmower if owned by me at the time of my death. Now, the reason we put that little clause, if owned by me at the time of my death, is that let's say you get rid of your riding lawnmower. Uncle Jim may step forward and say, hey, I think that riding lawnmower was worth $3,000. Mr. Executor, I want you to give me $3,000. Now, Uncle Jim is probably not going to win that case if it has to go to court, but we don't want to go to court. So this is one way for the executor to be able to say, this is what's happening. A really good little strategy that you can use, you can keep what's called a letter testamentary alongside your will. And as things come into your life and leave your life, and you're buying things and you're selling things, you can put a little instruction to the executor and say, I'm including a letter that will describe for you where I want things to go. That's not binding on the executor, but it's guidance to the executor, and it makes it easier for the executor. All right. After you've distributed your personal property, then you're going to distribute your real property. This is your home. This is any real estate that you might own, property that you might own. Now, the only really critical thing about this is be sure that you're telling your executor what you want done with the property. This arises a lot in the context of say a lake house or a cabin, or maybe you own a special home that's been in the family for years. The executor is going to have authority to be able to either sell that or distribute shares of that property. You just want to be very clear that that is what people want. All right. So if you want to keep that in the family, just tell the executor, I want you to distribute shares of that cabin versus I want you to sell it and distribute cash. All right, so there you've got your paragraphs all set up. Now we're going to make this legal. And the way we make it legal in Utah is you need 2 witnesses to be able to say that you had capacity on the day that you signed. Under Utah law, those witnesses have to be over the age of 18. They can be named beneficiaries of the will, and that's different than many states. Many states, if you have your witnesses, they have to be independent witnesses that aren't beneficiaries of the will, but under Utah law, they can be. And then finally, the witnesses, I think the best strategy is bring them into the room, have them watch you sign the will, and then immediately sign right afterwards saying, yes, on this day, I was there. Alan seemed to have perfect testamentary capacity. So there you go. And that's the way that you would create a valid will on your own. Type it out, write it out, however you want to do it. Most of the time, people will do it on their computer because then you can go in and change things. Makes it very easy. All right, let's change to the next slide. All right, here's a really interesting holdover from the Wild West days. We've all seen this movie, right? Somebody gets shot in the stomach and they're slowly dying, and they say, bring me a piece of paper, and they write out, to my dear sainted mother, I leave all my earthly possessions. They sign it, they keel over and die. Do we have a valid will? Under Utah law, the answer is yes. And this is really a really great way if you have been thinking about trying to create a will for years and you haven't done it. Maybe you're going out of town, you're leaving the country for a little while, and you want to create something that's kind of down and dirty and fast. A holographic will is a perfect way to do this. So a will in Utah is valid without any witnesses as long as it states that it's a will. It's got to be written 100% in your own handwriting, and it's signed and dated. You also are going to want to revoke any former wills, but that's belt and suspenders. As long as the date's on there and the date's more recent in time than a printed up will, the court's going to respect this. So this is a great way, like I say, if you're going out of town, if you need to do something quick, if you want to make changes, a holographic will is a great way to do it. And I get asked the question all the time, well, what if I go to Office Max and I pick up one of those wills that's fill in the blank? It has a lot of typing on it, but it fills in the blank. No, can't be done. That's not a holographic will. It's got to be 100% in your own handwriting. Okay? All right, let's go to the next one. All right, when are you going to want to go to an attorney? You're going to want to go to an attorney if there is any question of legal capacity or undue influence. So we've talked a little bit about legal capacity. If there are people in your life who are going to go to war over whether or not you had capacity when you created the will, you definitely want to go see an attorney. What do I mean by undue influence? Well, let's say dad has always been pretty frugal and has always wanted to make sure that his will says that his money is just going to get split between his two children. Dad gets a new girlfriend. All of a sudden, he's spending lots of money. He's changing his will. The will is going 100% to his new girlfriend. That might be undue influence. So if there's questions of those things, definitely go see an attorney. It will be worth it. Might be a little bit more expensive, but it's going to create less fighting over the years. All right. If you have a large or complicated estate, you'll probably want to go see an attorney. What do I mean by a large estate? Well, if your estate is greater than $15 million in 2026, first of all, congratulations. You're doing very, very well. That's great. But that amount that's over $15 million is going to be subject to a very extensive estate tax at the federal level. And chances are your state is also going to tax that. So you'll want some tax reduction strategies if your estate is over 15 million. The good news is if your estate is under that 15 million, those federal estate taxes won't apply. There might be other taxes that will apply, but that big federal scary estate tax won't apply. And the other nice thing is you can give an unlimited amount of money to a spouse without any tax consequences. Now, when your spouse passes away, there would be tax consequences. So again, if you've got a big estate, just go see an attorney. It's worth it. What do I mean by complicated? Well, if you own multiple properties, let's say you own a property in Utah and you own a property in Idaho and you own a property in California, you're definitely going to want to talk to an attorney because you don't want to have to go through probate in all three of those states. And we'll get into probate a little bit more in detail. But if those properties are solely owned in your name, then they would have to go through probate in all three of those states. And we don't want to have to do that. Okay, so complicated estate. If you have a business that you want to survive you, if you've got, a complicated kind of business arrangement at multiple LLCs, definitely see an attorney. It will be worth it. What can you expect as far as how much it will cost? You can expect to pay somewhere between $500 for a really simple kind of a simple will that basically says, if I die, everything goes to my spouse. If my spouse dies, everything goes to me. Once we're both passed, everything goes to our children. That's a really simple will, and it probably will cost somewhere on the order of $500+. Just make sure you talk to your attorney and find out what that typical fee would be. You don't want to be surprised. If you're going to do a really complicated estate plan with a will, with trusts, with say, transfer on death deeds, creating a power of attorney, you could potentially spend up to $10,000 for a large, complicated estate plan. All right, let's go to the next slide. All right, let's talk about changing your will. The fancy legal word is revocation. Can you change or amend your will? Of course. But it has to be done carefully and it has to be done lawfully. The thing I hear most from people is, can I just go in and scratch certain provisions out and rewrite in names or things like that? And the answer is no. The reason is that the courts are going to have a really hard time figuring out, did that name get scratched out while you were alive? Did it get scratched out while you had capacity? Did someone, after you passed away, scratch someone's name out and write a new one in? So definitely don't do that. If it may make more sense frequently to just revoke your former will and create a new will. You can revoke a former will in a multitude of ways. You can tear it up, you can burn it. My favorite way is just write in big black magic marker, revoked, across each of the pages, and sign and date when you revoke it. Take that old will and put it right next to your brand new will. That way, if anybody decides to go to war and say, hey, I think there was a will back 5 years ago that maybe is more current and a better will than the one that's right here. You've got the one that's right here, that's the new one, and right next to it is the revoked will, and so no one can go to battle over that, okay? Next slide. All right, if I were to have you guys in the room, I would ask the question, how many of you are terrified of probate? And I'll bet about half of the people would raise their hands and say, I'm terrified of probate. There's no reason to be scared of probate, especially in Utah. Probate in Utah is not particularly complicated. It's really just a three-step process. You basically have to collect all the assets. This is the executor. Once you've passed away, the executor kind of figures out what are all the assets that are in the estate. Then the executor figures out what are all of the liabilities and the expenses. And then those two things get balanced. Any estate taxes have to be paid at that point. And then you go through the process that everybody seems to be afraid of, which is the formal transfer of property. The good news is for most of us, most of the things we own will not have to go through probate at all. If you own a house and you own it with your spouse as a joint tenant, when you pass away, that title, the deed to that property, immediately goes to your spouse without having to go through probate. But if it's solely titled in your name, and many of us do have property that's going to be solely titled in our name, then it would have to go through a probate process. We'll talk a little bit about what's called transfer on death deeds that make things a little easier. And we'll also talk a little bit about trusts that make that process a little easier. But know that this kind of happens day in and day out, and it's not typically very expensive or very complicated to go through the probate process unless you've got people that you know are going to go to war. And then it can get really expensive. So we'll talk a little bit about that and how you avoid that. But if you can name a beneficiary, it's not going to go through the probate process. So if you've got a 401k, you name a beneficiary. If you've got an insurance product, you name beneficiaries. If you've got other investments, stock portfolios, you name your beneficiaries. When you pass, those things do not go through probate. So don't be as afraid of probate as you might think. The other thing that's really nice in Utah, if your estate is less than $100,000 and you don't own any real estate, you have a very simplified probate process that is very inexpensive, very straightforward, really simple, really easy. All right, let's go to the next slide. Again, there are no costs for estates less than $100,000 in Utah. The average cost that you might expect to pay for probate is somewhere around $750-ish for legal fees, and then there's a filing fee of around $375. Larger or more complicated estates could cost more. Again, we don't want to be probating in multiple states. So if you are looking at your assets and you know that you've got assets in multiple states, let's do some planning so that you don't have to probate in multiple states. All right, next one. All right, so let's talk for a minute about other types of property transfers. This is really a helpful little guide for other things that you can do other than a will. Gifts are very nice. If you have opportunity to give gifts during your lifetime, it can be a really nice way for you to see how you're benefiting the lives of other people. You can give up to $19,000 to any person or any charity, any entity, once a year, completely tax-free on both sides. Let me say that again. So you can give up to $19,000 a year, and that number changes year over year, but it didn't change last year. It's still $19,000. You can give up to $19,000 to any person, tax-free on both sides. Now, that means if you've got that $15 million estate, again, congratulations, but you want to get rid of some of those assets. Let's say you've got 100 beneficiaries. You've got kids and grandkids and great-grandkids, and you want to benefit all of those people, and you've got 100 of them. You can give each of those 100 people $19,000, and all of a sudden, $1.9 million in your estate is gone, and you won't have to pay any taxes on it on either side. So that's a lovely strategy for not only minimizing your taxes, but also seeing that the lives of the people around you are being blessed. It's also really cool that if you're married, you can give $19,000 and your spouse can give $19,000. You can only do that once a year. If you're intending to give bigger gifts than that, make sure you talk to a qualified attorney or a CPA, because gifting taxes can get really complicated. But it's a lovely strategy, and I think it's one that if you are bumping up against that high dollar estate, you should really be thinking about and considering. Deeds are another way that you can eliminate some of that fear over probate. Now, I have a hard and fast rule that I'll probably say 3 times at least when I'm talking about deeds. That is, you need to see an attorney. Deeds are complicated and they can have really unpleasant effects. I know your kids would never do this to you, but let's say you quit claim the deed to your house to your oldest son, and your oldest son decides that he's going to evict you. Can he do it? The answer is yes, and you have no recourse. So don't use quit claim deeds. Don't use things like that as a tax or as an estate planning strategy. Let me veer off just a little bit now. In the last few years, Utah has created, and almost every state out there has, what are called transfer on death deeds. This is a really great thing. So what I can do is I can say, when I die, I want the deed to this house, excuse me, to go to X person. I retain that deed while I'm alive. No one can evict me from my home. No one can kick me out. That's lovely. But the minute I die, it gets transferred on death to the person who I want as my beneficiary. That way it doesn't have to go through probate. What's my rule? See an attorney. If you're considering a transfer on death deed, go and see an attorney. It'll cost you a few $100s. It'll be totally worth it to make sure that your deed is where it's supposed to be and how it's supposed to be. All right. Last thing I want to talk about is trusts. This is probably when I was practicing the most common question I would get is, do you think I need a trust? And the answer for most people is probably not. If you don't have a complex estate, if you don't have property in multiple places, if almost all of the assets that you have are going to go through probate without any issue, and no one in your life is going to go to war over it, then a will is probably sufficient. There is nothing wrong with a trust. Trusts are wonderful, but they're also quite expensive, and you may or may not need one. So if you go and see an attorney, that attorney should help you understand why a trust is being recommended. Is it because you have a child with a disability and you might need what's called a special needs trust? Is it because you're worried that you've got a fairly big estate and you don't want it going to your beneficiaries in one lump sum because maybe they're not quite old enough or mature enough to be able to handle that, and so you want it to go out in kind of drips? That's a good, valid reason. If when you meet with the attorney, they say, well, you want to avoid probate at all costs, I don't think that's a valid enough reason, at least in Utah. There are some places where I wouldn't want to have to go through probate, but Utah is a fairly decent state for going through probate. And like I say, as long as people aren't going to go to war, you probably don't need to go through the expense of creating a trust. I always tell people, everybody needs a will. Some people need a trust. All right. Okay, and that's everything that I wanted to share. So I'm going to, Darren, make sure that I don't have any other slides. I'm pretty sure. Oh, we went through these gifts. Yeah, deeds. Just make sure that you see an attorney. Most people don't need trust. So I'm going to just open it up to questions. I've seen a great number of questions come in through the chat. Keep in mind, I cannot answer really specific questions that are specific to you only. I can't represent you. I can't give you legal advice, but I can give you general information.
All right. So let's see here. Catherine has a question. To see if I understand correctly, if I state in my will that the money for the sale of my house goes equally to each of my children listed by name, then probate can be avoided?
No. Let me back up one step. So if you want your, say you have a property and you want people in your life to get the cash from your property, you're going to tell the executor to go ahead and sell that property. Now, the property is still going to need to go through a limited probate process no matter what. Even if there's a transfer on death deed, remember our three-step process of what probate is. The executor is going to have to know what the assets are. The executor is going to have to figure out, are there liabilities on that property? And then chances are very good you will have listened to me and it was a transfer on death. So it's not going to have to go through any kind of probate process to be retitled. Then the executor has all the authority in the world to sell that and then distribute the cash. So that's the process of how that would go.
Okay. Let's see here. How are estate taxes determined?
Okay. So once a person passes away, the aggregate of the estate is considered. Then the liabilities are subtracted out of the estate. The remainder, whatever that amount is left, will either be subject to estate taxes or not subject to estate taxes. If it's $15 million or less, then you will not have any estate taxes at a federal level, and almost every state follows some kind of federal process. They use the same $15 million threshold. So, like I say, if you've got 15 million or more in your estate, and we laughingly say, hey, that's so much money, nobody could ever worry about it. But that's not really the case anymore, right? If you've got a significant piece of property, that could easily be worth $15 million. Okay, let's say you've got a farm that's 150 acres. That could very well be worth 15 million. So you're going to go see an attorney, you're going to think that through and find some estate tax reduction strategies. But for the great majority of us, we're not going to worry about estate taxes.
All right. What are your thoughts about setting up a trust through a credit union / bank benefit?
Yeah, so this is a question about whether or not you have someone who could be the trustee of your trust. If you don't have someone who you want to name as the trustee of the trust, and let's just make sure we're keeping all of our terms clear. You have a will and you have an executor or an administrator of your will. That person's job only comes to life once you pass away. You have a trust. That trust is created while you are alive and it lives after you die. Okay? So the trustee of your trust absolutely can be the same person as your executor. It doesn't have to be, but that trustee's job starts the minute you create your trust. Okay? So again, this is why most of us probably don't need a trust, but if you're going to create one, make sure that you've got the trustee set up. If you don't have someone in your life who could be that trustee, credit unions, banks, law firms, there's plenty of people who are willing to be that trustee for your trust. They're going to charge you something, and that's okay, because if you don't have somebody else in your life who can do it for you, having that person really is a good idea.
So Chemo has a question for you. Will a new will revoke an existing trust?
Oh, great question. Yeah, keep those two things very separate in your mind. A will supersede an old will. A trust, on the other hand, is going to live. It's alive while you are alive, and it survives you after you pass away. So the will really has nothing to do with the trust and would not supersede your trust.
Okay. Question from Joy. I have a house with my two sisters, and it is listed with all of our names and is in tenants in common. Can we all fill out a transfer of death?
Yeah, so what's my cardinal rule of dealing with deeds? You're going to go see an attorney and you're going to sit down with that attorney. The attorney will figure out whose name actually is on all of the deed documents. You'll probably have to have that person go back in time a little bit, check the titles, make sure that that is really clear, and then that attorney will guide you through the process of creating the transfer on death.
All right. I'm scrolling down to some more questions here. Let's see here. Jump to the new messages instead of just scrolling to them. All right. Is it up to you what you pay your executor, or is there a certain amount of legally required? So I guess they're asking about pay to your executor.
Yeah, so the executor can ask for reasonable reimbursement. And what that means changes over time. So you can try to restrict that in, say, your will, but there are certain things in your will that if you say them, they aren't necessarily going to be binding on the court. So let's say you said to the executor, you can get $1 an hour for the work that you do. That's not going to be legally sustainable. The executor can approach the court and say, hey, I think a reasonable amount might be $50 an hour. The court's probably going to agree with that. So just know that there's going to be a reasonable amount that is, most executors are our kids, and they do this for free. But if you have a paid executor, the paid executor is going to be able to say, this is my rate, and as long as it's not exorbitant, the court will probably allow it.
So this question comes up a lot, and you can talk about the different situations with it. Can you be your own trustee of your trust while you are alive?
Absolutely. This is the most common, and I'm not going to go super deep into trusts because they can get really complicated and really more of a 202 discussion instead of a 101 discussion. But the most common kind of trust that people create is what's called a revocable living trust. That means I create it, and while I'm alive, I get to put things in it, I get to take things out of it, I get to be the trustee of the trust. So I'm fully in charge of all of it. If for any reason you create something, though, that is very specific, let's say that you create a trust for the purpose of educating your children. And at some point you decide, you know what, I really don't want to educate my children anymore, or my kids are all grown and they're done. And I want now to sell one of the trust assets and go on a great vacation. Well, believe it or not, I know your children would never do this, but those people who are the beneficiaries of that trust could potentially sue you and say, no, you can't, because the trust assets are specifically set aside for education. Now, the great majority of revocable living trusts are created with complete authority for the person who creates it and who's the trustee to do anything they want to with it. And that's great. But know that those assets, some people think, okay, well, I created a trust, and so now I can never be taxed on it. I can never have creditors come after it. But the looser that a trust is, the more likely it is that a person could attach assets in the trust. So, again, trusts are wonderful. I just think that if you're going to consider one, you should have a good rationale for why you're going to do it, because trusts can be quite expensive. They can be multiple thousands of dollars to create, and you definitely want to review them every 2 or 3 years to figure out what's in the trust. Is it doing what it's supposed to be doing? You may have fairly extensive legal fees at some point to get rid of the trust, to change the purpose of the trust. So just be thoughtful about the way that you consider the trust. And, probate in Utah, $1,000-ish these days, considering the fees, the filing fees, all of that stuff. Creating a trust in Utah, $2,000-$3,000. So, you got to weigh those things out. And again, I just find that most people have been talked into the idea that probate is scary and that trusts absolutely eliminate any risk of probate. Those things just aren't that true in Utah.
So we're coming up to the top of the hour here. Would you like to take another question, or would you like me to talk about our next webinar and stuff like that?
Yeah, let me take one last question, and then I'll kind of wrap things up, and then I'll throw it back to you.
Okay. So I had a question where a person is an executor of people that are out of state, and they've heard that once both of those people pass away, that they would be required to get an attorney to handle those because they live in a different state. Is that true?
Not necessarily, but chances are pretty good that if you live in one state and all of the estate assets are in another state, chances are very good you're going to want an attorney anyway to help you walk through that, just to make sure you're doing everything right, you're filing everything correctly. So I would suggest in that situation that you probably want the services of an attorney. As long as nobody's going to go to war, chances are it's not going to cost you too much, but you definitely would want the services just to make sure that you're squared away and you're doing it right.
Well, thank you, Alan. That's great. There's lots of wonderful questions and we wish we could get to them all, but we are running up to 8 o'clock now. A quick reminder to everybody, a link to this recording will be sent out to you. It'll be on our YouTube channel and it'll be in our thank you email, but that will be probably next week before you see that. But there will be a recording of this that you can come back and watch at a later time. And also the document that was given out, I'll put in the box again to make sure that everybody has it. It's about whether you need a wills or trust and has questions for you. Again,
Yeah,
that's
it's
been
basically, it's the outline of everything that we talked about today. The other thing I want to offer to you is if you have questions that I didn't have a chance to answer. Again, I can't represent you. I can't answer specific legal questions to your specific thing. But if there was something I said that wasn't clear, feel free to email me. I'll put my email in the chat, but my email address is Ormsby, ORMSBY, Ormsby at AARP.org. So I'll put that in the chat now.
brave soul. But he said you could send him an email, so go right ahead.
No, feel free. It's funny. I provide this presentation all the time, and I will tell people, feel free to email me. I'll get maybe half a dozen. Sometimes I get a dozen, but I'm happy to try and answer those questions. Again, sometimes if you give me a really specific question that's about you and you alone, I'll say, sorry, this is delving into representation. I cannot do that for you. Go see an attorney. But if there's general questions that you have, I'm happy to answer them.
Great. So thank you, everybody. If you enjoyed today's webinar as much as we did, please join us for our next class in this series on Monday, March 9th at 11 a.m. This webinar will discuss digital tools for brain health. There is a QR code on your screen that you can scan now and register if you're interested. It will be free just like this one. It's about an hour long with a chance to ask questions live. If you can't access the QR code, head to aarp.org/Utah webinars to sign up. Our next webinar, like I said, is the digital brain tools for brain health. Our evening webinar in April will be with the FBI here in the state of Utah. So we strongly encourage you to go to our webpage and sign up for that broad webinar in April. It will be a great time to discuss what's going on. And we have other ones on our webpage too. We have one on chronic pain that will be coming up and also on pets. So if you enjoy some information about pets from the Utah Humane Society, please join us in June. So again, thank you, Alan. Thank you for sharing your wisdom with us. And thank you for participating. And I will stop sharing my screen and we will end the recording. Anything else you want to share, Alan, before we go?
No, just thank you so much. And as Darren said, we've got a lot of great, exciting things. So join us.
Yes. And have a wonderful evening. Thank you very much.